What's my take on the Abby Zwermer verdict? Well, hang on a second and I'll tell you. This is a postscript video, and it looks at the ultimate result of a trial, and it looks at why the jury may have decided the way they did and what to make of it. It's complete opinion, all my opinion, and that doesn't make it right. It just makes it my opinion. So take it for what it's worth. Let's get started. There are some days things just don't go well, and today was one of them. I was supposed to be out of the house around 5, wound up getting out of there around 6. Didn't get down here to Miramar Beach until almost 11 o'clock, and I've been waiting for the guy for the air conditioner since then. He's supposed to be here by 1, and he's got 3 minutes to get here. But be that as it may, I am patiently waiting, and I decided it was far past time to get this video out, a postscript to the Abby Zerner trial. So people have asked what went wrong with the jury. What happened? Is Abby going to be satisfied with the verdict? Is it subject to appeal? What could possibly happen? Let's not horribilize. Let's not go there right now. The insurance company at this point has every reason to settle this case and absolutely no reason not to settle it. And they're not going to do it right away, but within a couple of weeks, probably after pre-trial or post-trial motions are heard, they're probably going to pay up. They're probably not going to give, they're going to offer not to give the full amount, but they're going to wind up giving close to that. And I don't think, in my own opinion, that the amount of money really matters to Abby. In pretty much every case I've handled where somebody has been grievously injured, and I think you have to admit Abby is pretty badly injured. They don't want money so much as they want accountability. They want somebody to stand up and point their finger at the defendant and say, "You messed up. And because you messed up, you owe that gal some money." And she got that in court yesterday. And I'm proud of her. I'm proud of her for sticking it out. It would have been much easier not to face that hectoring cross-examination that she went through, but she stuck it out. She did the right thing for the right reasons, and you have to love what happened for her, even if you don't love what happened to her. So, what led to this verdict? Well, I got a great comment on the channel, and for the love of heaven, I can't find that comment anywhere now. But basically, what that comment said was the moment that the defense counsel started to cross examine the first witness, I was immediately amazed at how angry and upset and blaming that they were. And then they continued to blame everybody but their client for what happened. And she made comments about the closing argument. One person made the comment that I made the comment on my video that I don't usually scream at the video screen when I'm watching something, but I did when I heard that about we all think of, we all offer her our sympathy. Well, no, you don't. You badgered her like she was a toddler up there on the screen, and you should have been ashamed of that. I think it would have been a good thing for the defense if she'd have come back and said, sometimes to get people to admit what they don't want to admit, you have to ask really tough questions. And you kind of have to get into their face. And if that bothered you, blame me. Don't blame my client. Blame me. But this team did not have the level of self-awareness necessary to do that. I don't think they saw anything wrong with their cross-examinations because they've studied in the My Cousin Vinny School of Cross-Examination. And they think that all's fair in love and war and litigation. And that's just not the case. The actions and the machinations of the defense counsel in this case were, I thought, extremely counterproductive. If you want to have a good relationship with the jury, you have to be either a lady or a gentleman. You can ask tough questions, but you don't have to put tone in your voice that says you're a maggot. You have to be, now, sir, isn't it true? You agreed in your request for admissions that you could have taken the bag. correct? And that doesn't come off as ugly. But when she did it in her closing, it came off ugly. Pretty much everything she did in her closing came off ugly. But I was at least pleased that they didn't put the man up there to close, because I didn't think he was doing a very good job at any point during the trial. So I think, pretty much like I said in one of my videos, that no trial lawyer ever gets $10 million from the jury. The defense counsel gets it for them. I think that's true. But countervailing that, on the other side of that, we have to recognize that, at least to some extent, the defense was effective in reducing the amount of the judgment. Abby had sued for $40 million. In Virginia, you have to state the amount that you're suing for in your petition. In Missouri, by contrast, you say you want a such fair and reasonable amount as a jury may award. And you do that because you don't want to name a number, because something may seem like a really great number at the beginning of the case, $2 million. And then you may find out that your client is never going to be able to walk again, or has lost some other intrinsic ability that he had that you didn't know when you put the petition together or the complaint. So now what you have to do is you have to go back and amend, and it becomes a source of cross-examination. You started out asking for $2 million, and now you're asking for 20. Or worse, you have the situation like you had in the the bad coffee case at McDonald's, where the lady got burned. You have that situation where they put up a huge number, and for whatever reason, the jury grants it. And it makes it look like they just went in there and told the jury what to do. You don't want to do that. So Missouri solved that problem by saying, here's the rule. You ask for a fair and reasonable amount such that a jury may award it. And then you get to argue for whatever amount you want. If you want 15 million, if you want 20 million, you can ask for it. And here's the really good thing. If you go into the mediation and you say, look, our demand has been $10 million, but we'll take 5. And the defense says, no, we're going to take it to trial. And then when you get up in closing and say, I want $15 million for this case, they can't jump up and say, hey, they were ready to settle for $5 million earlier, because settlement negotiations and the contours of them are never admissible at trial. And so, again, every state has a different procedure in this regard, but that's the procedure here in Virginia. You put it in the complaint. So, did she prove up $40 million? I don't think she did. I realize she's got a bad hand, and life has certainly dealt her a bad hand in the card playing way, but she's got this bad hand, and she's got a bullet lodged between her heart and her spine. My guess is that that bullet was going to do her any harm, it would already have done it. It may sit there, it may get, I think in some cases it gets sort of cocooned by the body in there, and it'll never migrate. But we had a kid who was injured in a turkey shoot. He got hit by about 15 shotgun pellets, and over the course of the next year, they all worked their way out to the skin and came up like a big pimple, and they had to go in and cut it and pull it out. So it can wind up being the death of 1,000 paper cuts, but I don't think it will be in her case because of where it's located. So I don't know that they necessarily proved the $40 million. I think her